Welcome back to the Legal Roundtable here on the Oscar Pistorius trial, a carte blanche channel. Now, I'm joined in the studio by tonight's legal experts. Closest to me, Chris Greenland, former Zimbabwean High Court judge, former South African acting High Court judge. I've got defence attorney Renier Spies, and I've got Professor James Grant from the Wits University. Gentlemen, welcome to all of you. Thank you so much
for having us. It's
been a break that we've had. It's comforting to have you all around to put into perspective what's been happening. I normally do these things chronologically, but I'm actually going to jump to Pistorius's time in the witness stand. And I was looking, Chris, I'll start with you in your capacity as a former judge. I'm looking particularly at Judge Masipa's body language as Oscar Pistorius reads out that apology. For a judge, how unusual is it for a witness, an accused, to start their testimony in that fashion?
I think that it's fairly unusual. Normally expressions of contrition and remorse occur after conviction.
Yes.
So usually what you find in court is that people will fight a case to the bitter end and have a change of heart if and when they are convicted. In South Africa, we've changed that a bit. We tend to get sick after conviction and sentence. But I would say that it's not usual. But of course, in this case, it is at the heart of Oscar's defense that the killing was a terrible mistake.
Yes.
So saying that he is sorry in such a, I thought, wonderful way should be expected.
Okay. Tactically, Renier, what do you think of that move by the defence?
Well, I first of all have to agree with Chris in the fact that it was certainly very unusual. Tactically speaking, I wouldn't have done it. I wouldn't have advised my client to do it. He's had ample time in the preamble to the trial to express his remorse by way of letter, by way of a personal meeting arranged with the different parties. Certainly, a court of law is a corrosive place.
Yeah.
We are still in the midst of battle. And there's a flip side to this. It should not be seen in isolation. The first thought that went through my mind was, is this the gentleman to whom Riva replied per SMS that sometimes you scare me and I'm ad-libbing? And I'm sure that Gerrie Nel, being the very good cross-examiner that he is, and he's already shown that, he's going to explore the timing, the wording, and the very emotion behind this apology. Whether it's sincere, only Mr. Pistorius will know. Whether it's appropriate, many people will differ from me when I say no.
James, what do you think?
I think I have to agree with my colleagues. It's clearly unusual, but the fact that it's unusual, I think, could well count in his favor by virtue of the fact that this isn't an after the conviction expression of remorse. This is an upfront expression of remorse. And so the court isn't going to be in the position of saying, yes, you've expressed remorse, but you're expressing remorse at being convicted. And so it does help on that front. Aside from that, we mustn't lose perspective on what really matters here. And what really matters is those 4 or 5 seconds when you pull the trigger.
Yes. Renier, you were the person who flagged it right at the beginning, on day one, and we had the plea explanation, and it was an aggressive plea explanation. Would the expression of remorse not fitted better there? Would Gerrie Nel's first question under cross-examination, if he's going to address that issue, not be, why now? Why not earlier?
Yeah, David, you know that we must have regard to the purpose of a plea explanation. And a plea explanation is not to show remorse. I must agree with James in that it is at an early stage an indication of that remorse, and it will certainly function in his favor whether he's convicted or not. So no, I don't think that it would have been appropriate to put it in the plea explanation. I've stuck my neck out right at the beginning and say that the defense team made a PR exercise of the 115 statement. If I was Renier, and he was obviously very diplomatic, not wanting to cause too much uproar and trouble, get on with the job. He didn't object against its contents because certainly they dealt with certain aspects which you would not regularly find in a plea explanation. What I think is more important, though, is what was said in the plea explanation in the absence of what was alleged in the bail affidavit.
Yes, okay. Chris, and I don't want you to put yourself in Judge Masipa's shoes and presume to know what's going on in her mind, but can you put yourself in that position? If you were the judge in this matter and that was the way things started, there was almost, took the sting out of it by saying, sorry, I can't hear you. But I was trying to read her body language and trying to think, how is she receiving this? How do you think you would have received it had you been the person in the red robes?
I think it's better for me to give the public an idea of how a judge would be looking at Oscar right now. And obviously in saying that, I'm saying what I would do.
That's what I want.
Because it's at the heart of this case that Oscar is believed from the defense point of view. He's going to sink or swim on his story. I think we all agreed on that.
Yes.
There are serious questions of fact and even bigger questions of law that arise depending entirely on his performance. So from the judge's point of view, it's extremely important that she pays very serious attention to him as a witness from the beginning. And I picked up three aspects here. Firstly, his expressions of remorse. Tonight, as a judge, I would be making a note that to me it appeared sincere. I would have a positive first impression about that.
Yes.
Secondly, and I thought more importantly, is his life story. The immense challenge as a human being that he overcome. I was incredibly impressed with that.
Yes.
And that's what I would note. And then thirdly, which was the only real bit of evidence that came out on the facts, the boating accident. There I would put a question mark, because you will notice that he gave very good evidence on this accident, this boating accident, without actually telling us what his boat collided into and who was responsible. There's what we call a delicious vagueness about any responsibility or accountability on the part of anybody, starting with himself. So there I would put a little question mark. I want to make it clear that these would simply be my preliminary impressions as a judge, which I will then factor in when I have to consider the case at the end.
Well, let's keep going through it. And you were nodding there, James, at the point. I think there was a lot. I did see it on social media. I got a few SMSs earlier about why are we hearing all this stuff that doesn't relate to Valentine's Day? Why are we getting this history lesson, the biography of Oscar Pistorius? Your thoughts there?
I think there are two things going on. The one is to paint the picture, to launch the defense that he has this sense of vulnerability. He's far more likely than any other person to conclude in the middle of the night, if he hears a noise, that it must be a burglar. And I think that that's entirely consistent with their defense, and that's the way that the defense needs to go. I worry, though, that some of the evidence could have stepped over the line and been evidence which really relates to what we would call good character. He was suggesting that he's a good Samaritan who comes to the assistance of others in need. He loves dogs. He's a good Christian. Now, these are things which actually paint him in a good light and seem to be an attempt to make the argument that I couldn't possibly have done this to Reva intentionally because I'm such a good person. Now, I think it's entirely possible that the court is going to take that view, and if it does, it triggers the rules which allow Renier to respond and bring to lead evidence of bad character and to cross-examine Oscar about bad character. And that, I think, is a gate that has now been opened that Renier is going to really enjoy.
So when you say lead evidence, reopen his case?
He could, in fact, now, by virtue of the good character evidence that Oscar has led himself or brought himself or testified to, he could now respond with other witnesses. He's entitled to lead in terms of 197A. other evidence.
Would you do that, Renier, if you were in the defence's shoes? How would a defense legal practitioner approach a prosecutor, I beg your pardon, approach this?
I must say I'm a bit more skeptical than my learned friends on the left and right of me. I got the impression constantly that they are overplaying the sympathy card. I'm certainly more critical than most of this. I think that much of the evidence was unnecessary and irrelevant. The tone of voice, the demeanor of... look, we didn't see him in the witness stand, but he had a very certain, almost teeming kind of tone of voice, close to tears constantly. I would have been very careful to do too much, to give too much, get to the point, do it in sections, get it done with as quickly and as effectively as possible, and let's man up and face cross-examination on what you say is the truth. And just stick to the truth then.
It's not important for Barry Rood to establish where his fear of an intruder comes from in the first place. So he needs to establish...
But David, what has a Jack Russell got to do with that?
I do take there are
way
elements.
to wherever and went and fetched a little puppy that was suffering, and, you know, come on.
Yeah, but
Excuse me, Chris, you were going to say.
Go for it, Chris.
Without being argumentative, I think the defense has no option. If Oscar is to be believed, then the whole of Oscar has to be presented, served up to the court, made up of the judge and two assessors. They have to understand him in every conceivable way. And that is why I think maybe we've got an overkill on these issues that my colleague has referred to.
James, is it overkill?
I think you went too far. I worry, and that's what I'm calling the stuff about good character. I think that stuff was going too far. It was, I think, irrelevant to the issue at hand, which is, I understand, about establishing that he feels far more vulnerable and is the sort of person who might well have made that mistake. That's what the evidence supports. Talking about how he looks after dogs and he's a good Samaritan and all of that stuff, I think is what Renier is talking about, going too far. And I worry that triggers the right to cross-examination about bad character.
So it's all about opening the gate on being cross-examined on these issues. Absolutely. That you say should not be even open for cross-examination.
Well, not necessarily, but David, again, we must be very careful to consider evidence in isolation.
Yes.
We must constantly have regard to the evidence of witnesses during the state's case that specifically dealt with Oscar's actions at certain alleged events. In the absence of statements put to those witnesses by defense counsel in contradiction of those versions, which specifically dealt with outbursts of anger, a total lack of fear in certain instances. I recall the incident in the middle of the night where he confronted, on the version of the state witnesses, an armed, uniformed police officer, and so forth and so forth. So, looking at the evidence now, I think that kind of amplifies the flip side of that coin.
Okay. Chris, I'm going to give you one last comment and then we'll go to a break.
Yes, I think the public should understand that normally in court character evidence is inadmissible. So if the state brings up a serial killer to court, the judge doesn't know, and the state can't let the judge know that this person has killed 25 other people in the past. So that's what my colleagues are referring to.
Yes.
But if the accused then gives evidence, as they say Oscar is doing here, to say, look how good I am, look how beautiful I am, etc., giving evidence of good character, it opens the door for the state to then lead the evidence of how bad you were in the past.
Okay. Now remember, you can join us on Twitter, on Facebook, on Instagram and WeChat by searching for Oscar Trial 199. A little later in the show, we'll be looking at some of your tweets that were sent to the legal panel. We'll answer those. Those are the tweets that came to us via the hashtag Roundtable199. I'll see you right after the break.